Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2 in Jefferson County, Texas. You have been asked to come here for what is called an arraignment. An arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have in County Court at Law number 2 is a misdemeanor case. County Court at Law only handle misdemeanor cases. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type offenses. However, your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, your felony offenses are handled in the district court. For example, you could either have a capital murder, a first-degree felony, a second-degree felony, third-degree felony, or a state jail felony. Now, if you have a state jail felony case, the range of punishment is 6 months to 2 years in the state jail, or fine up to $10,000. If you have a third-degree felony, the range of punishment is 2 years to 10 years in the state penitentiary, a fine up to $10,000. If you have a second-degree felony, the range of punishment is 2 to 20 years in the state penitentiary, fine up to $10,000. If you have a first-degree felony, the range of punishment is from 5 to 99 years to life, a fine up to $10,000. Or if you have a capital murder, the range of punishment is either life or death. Now, in misdemeanor court, we only handle misdemeanor cases. Your misdemeanors are classified either as a Class A misdemeanor, a Class B misdemeanor, or a Class C misdemeanor. Your Class C misdemeanors are normally handled in the JP court, which is the Justice Court, or the municipal court, which is the city court. However, when those cases are appealed, they come to this court or come to County Court at Law, and then we will handle those cases on appeal. Now, for a Class C misdemeanor, the range of punishment is fine only. You cannot be given any jail time. You only could be given a fine. For example, if Class C misdemeanor will be a traffic ticket or not wearing a seatbelt. Cases in that category. Now, for a Class B misdemeanor, the range of punishment is confinement in the county jail. It can range from 0 days up to 180 days, which is 6 months, and or a fine from $0 up to $2,000. If you have a Class A misdemeanor, the range of punishment, confinement, 0 days to 365 days in the county jail, a fine from $0 to $4,000, or you could be given a fine and or jail time. Now, you've been asked to come here on a misdemeanor case. Now, as a defendant in a criminal case, you have rights. And one of the rights you have a right to have an attorney. Now, that paperwork that you have before you, that first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. I will go over this document with you. And it reads, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign on the line that says defendant, and you will date it today's date on the line that says date, and the day's date is April 12th of 2022. Now, for those of you who will be desiring to waive your right to an attorney and represent yourself, you will have to read and sign the next document. The next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Number 1, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 12th day of April of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that's your choice, then you will sign on the line where it says defendant, and you will date it today's date, which is April 12th of 2022. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a trial by jury. And that section over there that I'm pointing at, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury. And after listening to all of the evidence, they will decide whether or not to find you guilty or not guilty. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, you will not be having a trial by jury. And if that happens, then your case will come before the court or before the judge in one of 3 ways. One way it could come before the judge is by way of a trial. We call that trial a bench trial because it's a trial before the judge only. And the judge will listen to the evidence, and after listening to all of the evidence, and after arguments, the judge will decide whether or not you are guilty or not guilty. Now, if the judge finds you guilty, the judge will assess punishment. Now, if the judge finds you not guilty, then your case is over. You have been acquitted. You also have a right, the other way it comes before the court is by way of a plea. Now, there are 2 types of pleas. One type of plea is called an agreed plea bargain. And what an agreed plea bargain is, it's a way that if you're representing yourself or you have an attorney, they will negotiate with the district attorney's office. And if they reach a settlement on your case, they come to an agreement to settle your case. We call that a plea bargain agreement. And then that case will come before the court, and the judge can follow or not follow the plea bargain agreement. In essence, the judge can go along with the plea bargain or not go along. He can accept it or reject it. So, and if the judge follows the plea bargain agreement, and if you decide that you would like to appeal your case within 30 days, then the judge has to give you permission to appeal your case, okay? Now, the other way that the case comes before the court is by way of an unagreed plea, okay? What an unagreed plea is means that either you and your attorney have not been able to reach an agreement with the state to settle your case. And if that happens, then your case comes before the court or comes before the judge. And the judge will decide what the punishment will be, okay? So that's the third way your case comes before the court. So it can come before the court if you waive your right to have a trial by jury. It could come by bench trial. It could come by an agreed plea bargain, or it could come by way of an unagreed plea bargain. Now, you also have a right to have witnesses to come to court. And what witnesses do, witnesses can testify. They can testify either for you or against you. And if you are representing yourself, or if you have an attorney represent you, they have a right to ask questions. We either call that direct examination or cross-examination. And now you also have a right to waive your right to have witnesses, which means you have a right to give up your right to have witnesses. And by doing so, if you waive your right to have have witnesses to come to court, then you will not be having any witnesses that you'll be calling. That does not mean that the state won't be calling witnesses. It just means that you won't be calling witnesses in your case. You also have a right against self-incrimination. And what that means is the Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. And the state, no one else can force you to testify. Now, you also have a right to waive or give up your Fifth Amendment right against self-incrimination. And by doing so, you will be testifying in your case. Now, you also have a right to have what is called discovery. Discovery is you have a right to see the evidence that the state has against you. You have a right to see the documents, the witness statements, the videos, DVDs, objects, whatever the state has as evidence against you in your case, you have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery. In essence, you have a right to say that you don't want to have access to the evidence that the state has against you. Now, everyone here, you're either out on what is called a PR bond, personal recognizance bond, cash bond, or surety bond. That just simply means that you were arrested, you was in jail, and you bonded out. Now, every day that you spent in jail, it can be used as credit toward your sentence. For example, let's say you spent 5 days in jail, and let's say you and the state, your attorney has reached an agreement of 5 days in jail. What that basically means is that you will not have to serve any more time in jail because you'll be given credit for time served, okay? Now, if they are offering 7 days in jail and you serve 5 days already, that means you have to do 2 more. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. So, for example, every day that you spend in jail, you get credit of $100 per day towards your fine and court costs. So, for example, you spent 5 days in jail, that's $500 credit that can go towards your fine and court costs. So, if the state is offering you fine and court costs of $500, that means you won't have to pay because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they offer $700, you serve 5 days in jail, that means you have to pay $200. Now, let's say you can't pay the $200 on the day that you entered your plea. Then what can happen is the court can have you to pay it off in installments. What that means is you can be put on a payment plan until it's paid off. Now, let's say because of your financial situation, even if they put you on a payment plan, you couldn't pay it off. Then if that's the case, then the court can convert your fine and court costs to community service. Now, every hour of community service that you do, $12.50 will go toward your fine and court costs. So for example, if you work an 8-hour day, 8 hours of community service, that's $100 that can go toward your fine and court costs. All right. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders, people who haven't been in trouble before. And what happens is they will dismiss your case and you could get it expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. Now, in order to qualify, it has to be your first case. That's one. Two, you have to get an attorney to make out the application. And then three, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. Now, if you meet the qualifications, you get into the program, they dismiss the case, you complete the program, then you can get it expunged from your record, okay? Now, Jefferson County has another program as well. That program is called Veterans Court, and it's for veterans only. If you're a veteran of any one of the branches of the United States military, the Veterans Court program is a pretrial diversion program. It works the same way. And what I mean by that is you get into the program, they dismiss the case. You get into the program, you complete the program, they dismiss the case, you can get an expunge from your record, okay? And that's through the Jefferson County District Attorney's Office. Now, this court has a program that is called, we call it the Community Safety Initiative, CSI program. And what that program is designed to make Jefferson County a safer place by addressing the issue of recidivism. And recidivism means that when people commit crimes over and over, we call that recidivism. And so in order to address the issue of recidivism, this court started a program back in March of 2017 to address the issue of recidivism. And what we do is we have partnerships with agencies in the community. We have a partnership with the Spindletop Center, which is a local mental health organization. We also have a partnership with Spindletop. What Spindletop does is they'll give you a private interview. They'll draft an assessment plan. And from that assessment plan, they'll come up with a treatment plan. And that treatment plan could either be outpatient or inpatient treatment to address your mental health needs. Now, when I say your mental health needs, we're not talking about, you don't have to be insane or incompetent, but they address issues like anxiety, depression, bipolar, schizophrenia, post-traumatic stress, and a whole host of other mental issues that individuals have. And so they'll be able to address those issues. Now, if you have a problem with drugs or alcohol, then we have a partnership, Spindletop as well. Now, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And we have a partnership with the Alcohol and Drug Abuse Council. They have a program that is called OZAR. OZAR stands for Outreach, Screening, and Assessment Referral. And basically, what happens in that case is they will do a private interview, develop a screening and an assessment, and then you could be referred to either outpatient or inpatient treatment to treat your drug or alcohol issues that you may have. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you are trained in one of those areas that you choose, they will assist you at getting employment in the area that you are trained in. Now, if you haven't graduated from high school, CICE has a program for GED where you can get your high school equivalency diploma. Okay, so those programs that I just mentioned are programs that we have here in County Court at Law number 2. I tell people this all the time when you come to County Court at Law number 2. We do not just have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference in Jefferson County. And we believe we can make a difference in Jefferson County by not just giving out time, but by taking our time, by addressing the problem instead of just arresting the problem. And so with that program, we believe that we can produce productive people, and by producing productive people have too much to lose, and so therefore they will not commit crimes, and therefore our crime rate will go down. And so these are the programs that I've just mentioned. Now, the other interesting thing about these programs, all of these programs are free, does not cost you anything, and all of these programs can be used as community service. So for example, let's say, I tell people this all the time, you could kill 3 birds with 1 stone, and I'll explain that to you. And what I mean by that is, for example, let's say you was ordered to pay a fine and court costs. That's one thing. However, you can't pay the fine and court costs because you don't have the income. Then we convert it to community service. That's the second thing. And then the third thing is you're in one of the programs. It could be either drug treatment, job placement, job training, job placement. It could be mental health services, or it can be you working in the GED. And so while you in one of those programs, 1 hour in that program, 1 hour will go towards your community service, and $12.50 will go towards your fine and court costs. So you're doing one thing, but you're getting credit for 3 things. So that's the program that we have here in County Court at Law number 2. Now, that paperwork that has been handed out, take some time to fill it out. There should be a 3rd page on there for those individuals who will be applying for a court-appointed attorney. It is called an affidavit of indigence. Make sure you fill that form out. And if you need some help, we have some folks in our court who can assist you with that program. Okay, and so at this time, the court will be in recess to give you time to fill that paperwork out. And then we're gonna have court personnel to come by to pick it up from you. And then once we pick it up from you, then we'll put you in different categories. The ones who wanna hire, the ones who wanna apply for court-appointed attorney, and then the ones who wanna waive their right to attorney represent themselves, okay? So at this time, County Court at Law number 2 will be in recess, so just take some time to fill out that paperwork. And once the paperwork is filled out, just simply raise your hand. We're gonna come by and pick it up. We're gonna go through the paperwork, and we're gonna call you up one at a time. Okay?